Mediation is a non-court-based process. It is ideal for couples who are separating, possibly still living together in the same house and have children and finances that they want to discuss. Mediation assists parties in being able to reach an agreement over all issues outside of court. It is driven by the parties themselves rather than by solicitors or by the mediator. The mediator is there to assist the parties in their communications, finding solutions which are in the best interests of their family situation. So, for instance, a typical mediation may take 3 or 4 sessions if it's relating to resolving arrangements for where the children are going to live when the parents separate, how much time the children will spend with each parent, how the parents are going to communicate with each other over parenting issues. We also deal with financial aspects of the separation as well. So there's always a lot of anxiety around what's going to happen with money, where each parent is going to live, what are they going to live on, how much financial support they may receive from the other parent, and what sort of maintenance are they entitled to for the children. What the mediator is trained in is to be sensitive to the parties' needs, to pace the mediation at a pace which each of the parties can emotionally handle. So it may be possible that a mediator decides that the mediation should be conducted in 2 separate rooms, or that there should be breaks taken during the mediation. So the mediation process is driven by the parties, it's not driven by the mediator. A mediator is trained to manage the mediation process, and often the mediation meetings can be very stressful, emotional, and people express a range of emotions during the mediation. The mediator will help each party to focus on what it is that they want to achieve, what their goals are, and what they want for their family. It is a process which means that the mediator is independent. The mediator is not there to express opinions or offer legal advice. The mediator will urge each party to take legal advice during the process. It's important that both parties understand when they attend mediation that the meetings are confidential, that any discussions or agreements reached in mediation do not become legally binding until they've been legalised by their solicitors. Both parents will be spoken to if there are children involved, and the children are of a relevant age where it's thought it might be necessary for the children's input to be taken into account during the mediation process. For instance, children might have an opinion as to how much time they would like to spend with each parent, which parent they would like to live with. It is normally when a child reaches the age of 10 that this is something that is offered. It is quite an important process because it means that you have to engage with children that you've never met before, and you have to inform them and assure them that whatever they discuss with you will not be fed back to their parents unless they give express permission. We have done a number of direct consultations with children in the past, and parents have found that very rewarding and insightful, because there are often things that are going on around them that parents don't see. Mediation typically will take 1.5 hours for each session. It will normally take a couple of months to resolve all issues, and at the end of the process, the mediator will send to the parties and the solicitors a memorandum of understanding. What the memorandum of understanding contains is all the information that has been discussed in principle as to their arrangements for the future, living arrangements over finances and in respect of the children. It is then for the solicitors to put this into a legally binding agreement if both parties wish to proceed. The mediator will meet with each individual party to assess their suitability for mediation. This is also to carry out screening for domestic abuse and child protection issues. If the mediator considers that mediation should proceed and the parties are willing to engage because it is a voluntary process, then a joint meeting will be set up. Both the parties will know before the mediation whether or not the mediation is conducted in one room or two separate rooms. At the initial meeting with each party, suitability for legal aid will also be assessed, because legal aid is available for mediation for those parties who are on a low income or on state benefits. The advantage to a paying party is that they will get their first initial assessment meeting free and the first mediation free. Before then, they have to pay an hourly rate for the mediation. If both parties are privately paying, the costs of mediation are split based on hourly rates. They are split between them and they are required to pay for mediation as they go along. So typically you could spend around £500 on mediation, whereas if you went to court you'd be spending at least £2,500, possibly up to £10,000 if the case became contested. Family Law Group have a number of mediators, both male and female. We have a wide range of experience, both as lawyers and as non-lawyer mediators as well. And we're very flexible as far as offering appointments. We can fit in with your work commitments or your childcare arrangements. If you would like to arrange an appointment to come in and see one of our mediators, then please contact us.